Can I ask, firstly, Lord Advocate, last week the committee took evidence, and there was a great deal of discussion about what Section 162 of the Criminal Procedure and Licensing Scotland Act 2010 was intended to do. And of course, my understanding is that it's not what it was intended to do that's the relevant question here, but what it says. So can I ask you to explain what that legislation actually does, what the restrictions are in it, and how it relates to the kind of materials that we're talking about in our inquiry?
I'm grateful to the member for that question. And the first point, he is absolutely correct. Legislation is interpreted according to the meaning objectively considered of the words set out in the Act. The intentions subjective intentions of those who passed it are neither here nor there when it comes to deciding what a piece of legislation means. This particular provision imposes a duty correctly on the Crown to disclose to an accused person information that the Crown may have gathered in the course of the police may have been gathered in the course of a criminal investigation, or the Crown may have obtained that may be of assistance to an accused person in the context of their defence of a criminal charge. That's to ensure a fair trial. But the committee will appreciate that that may oblige the Crown to disclose to an accused person, or rather to his solicitors, because I should say the material always goes to the solicitors and not to the accused person himself, to disclose to the accused person's solicitors what may be highly sensitive, highly personal information that people have made available to the police and the Crown, or may have been required to make available to the police and the Crown for the purposes of the proper administration of criminal justice. And the law therefore puts strict constraints on what the accused person or his solicitors may do with that material. What the Act says is that they may use that material for the purposes of the criminal proceedings in relation to which it's been disclosed and in the context of any appeal. And there's a provision that they may not use it for anything else, and a breach of that is itself a criminal offence. Now, it relates, as I understand it, to the issues in the committee, before the committee, because Mr. Salmond has stated that his hands are tied in relation to material that he would like to provide to the committee. As I said in my opening remarks, if the committee wishes to see material, then it has a mechanism available to it by way of an order under Section 23, and indeed it was the Crown that, in correspondence with the committee, suggested that that would provide a mechanism which would allow the Crown at least to consider, according to the relevant legal rules, the provision of material to the committee. The committee has served such a notice on the Crown, and it's under consideration as we speak.
So, well, you've already set out in your answer there, I suppose, some of the reasoning around Section 162, but I just wonder, in that case, can you give a clear indication whether some of these restrictions that you're talking about would apply equally to other parties who are involved in this, say the solicitors of individuals, in the same way they would apply to the individuals?
Well, the material is disclosed to the solicitor. The solicitor is the agent of the client. The restriction would apply to the accused and to the accused's solicitor. I should say the solicitor, there are also professional obligations, as one would expect, that apply to solicitors in relation to the use of such material.
Can I have Murdo Fraser, please, to be followed by Alex Hamilton?
Thank you, Convener. Good morning to the Lord Advocate. I've two substantive issues I want to pursue with the Lord Advocate this morning. I want to raise this issue that Alistair Allen pursued with you a few moments ago about the application of Section 162 of the 2010 Act. And the reason this is significant is that in his evidence to us on Friday, Mr. Salmond made some very serious allegations that there was in effect a conspiracy against him. And evidence to support these allegations is contained in documents that his lawyers currently hold, but he cannot release to us as a committee because the operation of Section 162 of the Act would make it a criminal offence to release them to us. So can I just ask you, so we're clear, do you as the Lord Advocate have discretion as to whether or not Section 162 can be waived in a case such as this?
Well, there are no exceptions to the provisions of the Act.
There have been no civil cases. There have been no civil cases that you are aware of where you have agreed to waive the application of Section 162 to allow evidence presented in a criminal case to be utilised in those civil cases.
In the claims against me by Mr. Clark and Mr. Whitehouse, the question of the use of material that had been disclosed to them for the purposes of initiating a claim against me had to be addressed. The issue was dealt with through them taking a legal case to the applying to the nobile officium of the court. That's an exceptional power that the court may exercise in particular circumstances. And through that process, the matter was dealt with so that they could use that material for the purposes of initiating a claim against me. So a wholly different situation, and one in which the matter had to be, the matter was dealt with in the way that I've just described.
Thank you for that. So when you said to us there were no relevant exceptions, in fact what you meant was there are relevant exceptions if the case is pursued in a particular way. You see, the reason I ask these questions, Lord Advocate, is that we know that in the Whitehouse and Clark case, Section 162 was set aside to allow access to these documents presented in a criminal case to be used in a civil case. So we know there is an exception. That's already been established. And there are people who claim that the Crown Office is part of a cover-up, together with the Scottish Government, in not allowing this information to be provided. So given that we have a precedent for this having been done already, why is it not being allowed in this case?
Well, first of all, that's a wholly different set of circumstances. It was dealt with through the process that I've just described. Can I say absolutely that the Crown is not party, would not be party to any improper conduct. Can I just say in relation to the material, as I understand it, we're concerned here with material which was not admitted into evidence in the course of the criminal proceedings. I have not myself seen the material, but I think one can take it that it was not admitted into the criminal proceedings because the trial judge, Lady Dorian, took the view that it was not relevant to the issues in the criminal trial. And one can draw one's own conclusions as to the bearing that the material may or would or wouldn't have had, but one could take it that it was not relevant to the issues in the criminal trial. The committee can obtain this material by serving a Section 23 order on the Crown, and the Crown itself, in correspondence with the committee about the release of material, recognising that there are legal constraints on the Crown about its own use and its own disclosure of sensitive information, identified to the committee Section 23 as providing a proper legal basis. So it's in the hands of the committee to initiate those processes. As I understand it, the committee has served a Section 23 notice on the Crown last week, our second one. The committee served an earlier one to which the Crown responded in full. It's considered at the moment. So I reject absolutely any suggestion, any attack on the integrity with which the Crown has conducted itself in relation to these matters. And I should say, as I said in my opening statement, these matters have been put entirely in the hands of the most senior professional prosecutors in Scotland, and any suggestion of improper motive or improper behaviour is the most serious slur on their professional character and integrity, and it should not be entertained for a moment by this committee.
Thank you, Lord Advocate. We have, of course, as you say, served a Section 23 notice on the Crown Office. Mr. Salmond was also suggesting that we serve a Section 23 notice on his lawyers, who already hold this material. If we were to do that and recover the documents, and if they were relevant to our inquiry, would the Crown Office have any objection to us publishing that information?
I'm not going to comment on that on the hoof. That's something that would require to be considered.
Okay, thank you.
Moving on to the Criminal Justice and Licensing Act 2010, Section 162, if one can characterise this 162 as a deep freeze into which material is put and can only be extracted if the grounds of subsection 3 are met, or indeed, as the case you noted, the Office of the Noble Officium Court can access the deep freeze. Can you explain the terms under which, and that this was revealed in the Information Commissioner's report, there was a meeting on the 21st of August, and there was a statement made by Detective Chief Superintendent, whose name we don't know, in relationship to the handling of the internal misconduct investigation of the Scottish Government. That was provided by Levy and McRae to the Information Commissioner's office. Is it correct that their ability to do that was because of Section 131 of the Data Protection Act 2018?
There about whether it was followed from that particular provision. What I can say is that whilst the Crown was advised of Mr. Salmond's intention to disclose that statement to the Information Commissioner's office, it did not consent to that. And I suppose there are 2 points to make. That was the passing of one specific piece of information to an organisation charged with investigating what was a potential criminal offence under the Data Protection Act. You maybe have the advantage of me in having the section in the Data Protection Act in front of you, Mr. Whiteman. I'm afraid I don't. No, I'm afraid I don't either.
No, that's fine. We'll leave that. But to be clear, you didn't consent to that disclosure to the Information Commissioner Office?
No.
Okay, so that contradicts Mr. Salmond's statement in column 10 of the official report, where he says that the reason we were able to give the ICO a copy of that statement is because the Crown Office permitted us to do so. That's not correct in your view.
Well, I should be clear. I'm told it was mentioned at a meeting between representatives of the Crown and representatives of Mr. Salmond that they intended to do that. The Crown, noted didn't make any comment one way or the other, as I understand it.
Okay, thanks very much.
Maureen Watt.
Thank you, Convener. And being last, obviously a number of my questions have been asked already, so I'll be as brief as possible. First of all, we've heard a lot throughout this inquiry about the term legal professional privilege, or LPP. Can you explain how LPP typically operates for the Scottish Government, please, Lord Advocate?
Yes. Well, every client is entitled to take legal advice free, and legal professional privilege is the doctrine which entitles any client to keep its legal advice entirely confidential. It's recognised, routinely by the courts. It's such a strong privilege that it can't, unlike other obligations of confidentiality, it can't be overridden ordinarily. So any client's entitled to keep their legal advice wholly confidential. That's true of government as of others. The Ministerial Code recognises that in exceptional circumstances the government may decide to reveal its legal advice, and the Code sets out rules in terms of which the government must address the question of whether it would be appropriate or not to release its legal advice. It's fair to say that release of legal advice is exceptionally rare, and that's true not of all governments in the United Kingdom, of all political complexions, and has been for many years. But on occasion it does happen, and it happens when it's proposed that legal advice should be released. Then the Code sets out the rules in terms of the tests that need to be met before legal advice can be released.
Okay, I mean, in my lifetime, I suppose the legal advice on the Iraq War was asked to be published, and that's what the main one that we think about. But, is it typical for parliaments to pass motions asking for legal advice to be disclosed, in your experience?
Well, I have experience of being in this office for the course of this Parliament, and so far as I'm aware, it's only been in relation to this matter that there have been such motions. In this Parliament, I'm aware that there have been processes in the UK Parliament from time to time, and you're right to mention the Iraq War example. But as I said, it's exceptionally rare for all governments to release their legal advice. On occasion, they do so.